Hello there, it's Amy Peters from Beneficial Trust and Will Company. I just wanted to record this quick video to take you through a case that's been reported recently, the case of Peter Coady and Gerard Coady. And this is all about the statutory requirements of witnessing a will and where it can go wrong, or where it has gone wrong in this particular case. So just as a reminder, for a will to be valid, it must be signed in line with the statutory requirements set out in Section 9 of the Wills Act 1837, which fundamentally states that the will must be in writing, it must be signed by the testator, the person making the will, and the signature must be made or acknowledged in the presence of two witnesses who must also sign in the presence of the testator. Sounds straightforward, but in this particular case, in 2020, Kathleen Coady created a will appointing her son Gerard as the sole executor and the sole residuary beneficiary, and this actually replaced an earlier will from March 2017 under which Peter Coady, the now claimant, was the executor and residuary beneficiary. Following Kathleen's death in November 2022, Peter argued that the will was not properly signed and witnessed, as the will was drafted during the first COVID-19 lockdown restrictions. It was prepared by a solicitor and signed at home due to the social distancing restrictions that we all fondly remember at the time. And the key dispute was around whether the witnesses actually saw Kathleen sign. They said that they entered the back garden where a table had been set up about 12 feet from the back door, just referring to my notes, and Kathleen, the testator, was seated inside at a dining table 6 to 8 feet from the door. The witness described her as very ill, half asleep, frail and silent, making no acknowledgement of their presence. The witnesses did not see her sign the will and could not see them witness her, and she could not see them witness her signature. The entire process lasted 2 to 3 minutes. But Gerard's claim was different, so that was kind of the neighbours, the witnesses' account of events, and Gerard's account was different. He claimed that the instructions were followed precisely. The will was read aloud to Kathleen, and the witnesses could see Kathleen's signature, and she greeted and thanked both witnesses. And the court found this evidence to be suspicious and unreliable. So whilst they acknowledged the temporary extension to legislation which allowed for wills to be executed by video conference during the pandemic, they didn't feel in this situation that the witnesses met the requirements of being simultaneously present and acknowledging requirements as well. And therefore, they said the will was not valid for non-compliance with the signing requirements. It is just an example of how it may be a good option to review wills with clients who may have made them during the COVID-19 restrictions. I suspect there's also a lot of DIY wills that were put together during that time. So we always suggest that wills are reviewed, if there's any significant change to circumstances, or just generally kind of every 2 to 3 years. We've obviously got the autumn budget coming up, possibly changes in that respect. So things should be reviewed regularly, but it's just a good example of making sure that, we get really far with clients in terms of taking their instructions, making sure we draft wills correctly, but the signing process should not be forgotten. It's a real opportunity for you to support clients and also speak to witnesses who probably need to get their wills in order as well. So I hope that was helpful. Any aspects you want to chat through, then get in touch, and speak soon.